If one was to paint a picture of fair and equal housing, what would it look like?
What fair housing look like is a nation where people have the wherewithal to live, based on their financial ability to pay where they want to live and their tastes and preferences, not based on their race, their color, their disability, their sexual preference, family members, where their children exist, religion, and national origin. So it's a country that would be free of discrimination.
Unfortunately, that picture of equal opportunity doesn't exist for many reasons. It certainly has never been the case for housing in the St. Louis area. But the Civil Rights Enforcement Agency here has diligently fought to make that picture closer to reality. Here's some background. The Human Rights Agency was created in 1950 following a racial conflict that ensued when then St. Louis Mayor Joseph Darst ordered the desegregation of the Fairgrounds Park swimming pool. In response to the crises, the mayor appointed a council which recommended establishment of the agency. Executive Director Charles Bryson explains what CREA does today when it investigates and finds discrimination exists.
Depending on if they fit one of the federal, state, or local discriminatory causes, then we will either help negotiate a settlement agreement, which is called conciliation, or we'll actually file charges, as we have in several cases, using our resources within our city council's office to assist us.
CREA's work with the Housing and Urban Development and other agencies to increase access to all people and undo patterns of exclusion has made a big difference in the St. Louis region.
70% of the complaints that are received by HUD are investigated by agencies like CREA. And so it's important that we work together. CREA investigates complaints under their local ordinance, and they have some additional prohibitive classes. For example, sexual orientation would exist on the CREA ordinance, but not under the Fair Housing Act itself.
If someone believes they've been discriminated against, we ask them not to make a judgment. We ask them to call us. We then will take that information, have them fill out a form, a simple form saying this is what allegedly happened. We then will do the investigation and the follow-up.
How was Boone Center today? Fine.
Take, for instance, a complaint filed in early 2013 with HUD against the city of St. Peters by this woman, Georgia Conlon, on behalf of her sister, 49-year-old Julie McNames. McNames is a resident of a group home of intellectually disabled adults. She and the three women she lived with were told they could not move into another nearby place because of zoning laws. Here, Conlon tells the story.
A gentleman had bought this building, this house, specifically to renovate for these four girls and to meet their specific needs. And the city originally allowed him the permits, and then just about the time the house was almost finished, they said, you can't use this as a group home. It's too close to another group home. And that was about 800 feet from, as an eagle flies, from another group home that no one was aware of.
In investigating that complaint, we took a look at the minutes of the meetings in terms of how they discussed this, but this was a really kind of an egregious ordinance on the books for St. Peter's. So it required that, the public comment on any houses that may be coming in as a group home, and it also required that the city approve a variance. The city was unwilling to do that. So we met with them and saying, hey, this is a discriminatory ordinance on its face,
The city of St. Peters violated the law when it adopted and enforced a 2,500-foot spacing requirement on group homes. The lawsuit was settled after St. Peters agreed to pay a total of $80,000 to Julie and the three other women in the home, as well as make changes to its zoning laws. Julie's case spotlighted a surprising change in the type of complaints agencies are seeing now. Race, historically the #1 basis for housing complaints, isn't any longer.
Another case that involved disability discrimination in the city of St. Louis involved Patricia Afshar, who lived in a downtown loft apartment. At that same apartment complex, her son lived there in a different apartment. She had wanted to switch apartments with her son because the son's apartment was much closer to elevator and laundry facilities and other amenities, and the landlord and property management company denied that request. My office, under the ordinance, was able to file suit against the landlord and the property management company. which the ordinance allows. And we made allegations under the ordinance as well as the Missouri Human Rights Act for disability discrimination.
According to statistics from 2012, disability is the most common basis of complaints filed with HUD and FHAP agencies, being cited as 49.6% of total complaints. Race is now the second most common basis of complaints, being cited as a basis for 29.4% overall.
One of the major cases here that affected national law was the case of Shelley versus Kramer. Many of these neighborhoods had restrictive covenants, and so, for example, it was an all-white neighborhood. A homeowner there, was not allowed to sell that property to anyone else other than another white individual. And so the case of Shelley versus Kramer came about because African-American couple attempted to buy a house right out on Labadee, which is now an all-black area here in St. Louis. And so that case worked its way all the way to the Supreme Court.
The Civil Rights Act of 1968 prohibits the sale, rental, and financing of housing based on race, religion, national origin, sex, and as amended, handicap and familial status. CREA representatives say many strides have been made since 1968, but admit much still has to be done to totally change the picture of fair housing in St. Louis and in America.